Senator Plett.
Thank you. Colleagues, I rise today to speak to third reading of Bill S-13. As you know, Bill S-13 will amend the Interpretation Act to include a non-derogation clause on upholding the Aboriginal and treaty rights found in Section 35 of the Constitution Act 1982. That clause will read as follows. Every enactment is to be construed as upholding the Aboriginal and treaty rights of Indigenous peoples, recognized and affirmed by Section 35 of the Constitution Act 1982, and not as abrogating or derogating from them. Abrogation refers to the formal repeal or abolition of a law, agreement, or order. It signifies the act of formally and officially revoking or nullifying an existing law, treaty, legal right, or another formal enactment. Derogation is the partial suppression or relaxation of a law, rule, or agreement. It often refers to the act of deviating from a standard or norm, typically in a legal context, where certain aspects of a law or regulation are suspended or modified without completely eliminating the law itself. You can easily see why either of these are very detrimental in the context of the rights of Indigenous peoples. What perhaps is less clear is why such a derogation clause is even necessary. Allow me to give you a bit of background on how we got to where we are today. To do so, I'd like to quote a few paragraphs from a 2013 article entitled "The Campaign to Erode Aboriginal and Treaty Rights," which was signed by 52 professors, constitutional experts, Indigenous leaders, including Willie Littlechild and Constant Backhouse. And I quote, "Up until 1995, new federal laws that might have the potential to conflict with Aboriginal and treaty rights routinely included in a non-derogation provision, a provision confirming that Parliament did not intend the new law to be interpreted in a way that would conflict with Aboriginal and treaty rights. Starting in 1995, the Federal Government of Justice has worked, first, to chip away at then more recently to undermine directly this constitutional balancing act. It has done so without bringing the matter clearly to the attention of Parliament or Aboriginal peoples or the Canadian public." The article goes on, "In laws drafted since 1995, the Department of Justice has experimented with replacing the clear non-derogation language with many weaker variations. All those variations have trended towards a blurring, weakening, and eventually overturning of Parliament's previously clear presumptive intention not to diminish Aboriginal and treaty rights in new legislative projects. For quite some time, this campaign went undetected. When spotted by Aboriginal representatives and brought to the attention of parliamentarians, the Senate Standing Committee on Legislative and Constitutional Affairs carried out a careful and thorough investigation of the matter. The investigation resulted in a thoughtful report in December of 2007, supported across party lines, entitled "Taking Section 35 Rights Seriously, Non-Derogation Clause Relating to Aboriginal and Treaty Rights." Among the sensible recommendations of that report, the Senate committee urged that the Federal Interpretation Act be amended to include a general presumptive rule that new laws be interpreted to uphold rather than erode Aboriginal and treaty rights. Colleagues, this is the unvarnished backstory to the legislation that lies before us today. Bill S-13 is not a bill to be celebrated, but rather a silent testimony to the repeated and systemic failure of Canadian governments to honor Aboriginal and treaty rights. This is sobering, colleagues. First, we had the treaties. Then the treaties were followed by court decisions which insisted that those treaty rights must be honored. Then came Section 35 of the Constitution Act 1982, which affirmed that treaty rights are actual rights and must be respected. Following that, Parliament adopted the United Nations Declaration on the Rights of Indigenous Peoples Act, which requires that, and I quote, "States shall consult and cooperate in good faith with the Indigenous peoples concerned through their own representative institutions in order to obtain their free, prior, and informed consent before adopting and implementing legislation or administrative measures that may affect them." Yet, despite all of this, colleagues, we are now passing Bill S-13, which will once again affirm the rights of Indigenous peoples, even while the government simultaneously ignores Indigenous concerns about the bill. These concerns were repeated over and over again by Indigenous witnesses at the committee hearings on Bill S-13. Nathan Obed of Inuit Teperit Kanatami. By the time we're done here, colleagues, I'm going to have learned how to pronounce that, I think. I've done it a number of times. ITK has serious concerns about how the process for developing this legislation is being portrayed. The legislation was neither co-developed with Inuit, nor was it subjected to any consultation and cooperation with Inuit. The Women Natives Association of Canada said this: "Specific to this bill and to an NDC in the Interpretation Act, NWAC submitted at least 4 written submissions between 2021 and 2023, very clearly emphasizing that NWAC expects UNDRIP to be included in the non-derogation clause. We have been consulted, but they haven't responded to what we have been asking repeatedly." Cheryl Casimir, who is an elected political executive of the First Nations Summit Task Group in British Columbia, as well as a member of the BC First Nations Leadership Council, said the following: "From the perspective of the AFN, no, we don't believe that the principles of free, prior, and informed consent were followed in the creation of this bill. The AFN advocated that more consultation take place with all First Nations. Further to that, the bill was also tabled without proper information sharing to the AFN or to First Nations." Judy Wilson, former chief of the Union of British Columbia Indian Chiefs, said, "There hasn't been enough consultation through this process." Sarah Nemet, Director of Legal Services at the Native Women's Association of Canada, told our Legal and Constitutional Affairs Committee that Bill S-13 signals that Parliament is not as serious about doing the work behind reconciliation, but only to say the word for political gain. Colleagues, this government talks a big talk, but repeatedly fails when it comes to the walk. Their actions do not line up with their words. This is not an arbitrary accusation. I saw it in living color at the Defense Committee hearings on Bill C-21. Even while S-13 was passing through the legislative process, claiming that Aboriginal and treaty rights must be honored, the government was simultaneous trampling all over those rights on Bill C-21. Paul Erngut, Vice President of Nunavut Tungavut Incorporated, told the committee, "There has not been sufficient consultation on the bill. We feel we have not been adequately consulted." When Jessica Lazar of the Mohawk Council of Kanawaki testified, I told her that the minister had stated that the bill is respectful of Indigenous rights and that his deputy minister assured the committee. There were extensive consultation with Indigenous communities across the country when it was introduced for the first time, the words of the minister. I then asked Chief Lazar, just to be sure, did the government consult with you before this bill was introduced? She gave me a one-word answer, no. So I asked, are you aware of any extensive consultations held with Indigenous communities across the country before this specific Bill C-21 was introduced? Chief Lazar gave the same answer, no. Colleagues, when Minister LeBlanc appeared at Defence Committee on Bill C-21, he assured us that Indigenous groups had been consulted. Yet the record is clear. They were not. There was no consultation, no cooperation, no free, prior, and informed consent. You would think that the Senate Standing Committee on National Security, Defense, and Veteran Affairs would be the perfect place to address this clear violation of Indigenous rights. After all, the Senate is to be the chamber of sober second thought and protect the rights of minorities. Yet when amendments to Bill C-21 were proposed at committee to address this failure to consult and cooperate with Indigenous peoples, all of them were rejected. It didn't matter whether the amendments were introduced by Conservative members, and of course, you could say they were partisan, but Senator Anderson introduced amendments, and they failed. We watched as the same hypocrisy demonstrated by this government was repeated at committee, with some senators saying all the right things and pretending to value Indigenous rights, while simultaneously doing the opposite, ignoring Indigenous voices and trampling on their concerns. And we've seen it right here across the aisle, where Indigenous members voted for legislation that is trampling all over their rights. I occasionally use cartoons and so on and so forth as illustrations. I will do one again today. And some days I feel like I'm watching the old Peanuts cartoons, where Lucy sets the football down for Charlie Brown to kick. He runs towards the ball, and just as he winds up to kick it, Lucy pulls it away, and Charlie Brown falls flat on his back. But being an eternal optimist, Charlie Brown repeats this over and over, thinking each time that this time Lucy will keep her word. But of course it never happens. And we find ourselves chuckling at Charlie Brown's naivety. Colleagues, we do not live in a cartoon world, even though sometimes this government makes me feel like we do. Yet we have the same naivety that is on display right here in this chamber. Just the other day, Senator Deakin reversed her position on an amendment to Bill C-21 regarding sports shooters because she received a promise from the government that it is not their intention to take away shooting sports in this country for young people, beginners or older people. Senator Deakin was assured that the government is concerned about finding a balance between allowing legitimate shooting sports and competition while also not opening up the back door to handgun ownership. So, Senator Deakin said, I think I at least need to let them keep true to their word. Charlie Brown, colleagues, this is the road that will only lead to disappointment, discouragement, and dashed hopes. Because this is the very, very same government that not only said they would honor Indigenous rights, but then put it into law through the enactment of the United Nations Declaration on the Rights of Indigenous Peoples. Don't you think a minister's word will be enough when neither the minister's words on Indigenous rights, nor the treaties themselves, nor Section 35 of the Constitution, nor UNDRIP, nor the legislation before us today is enough for the government to keep its word? Senator Deakin does. How about the rest of you? They still trampled all over those rights by failing to consult on C-21. And yet I have no doubt that we are about to witness the spectacle of seeing senators again standing in support of this bill to support Indigenous rights just after having voted down amendments designed to protect those rights. It must be spectacularly discouraging for all Indigenous peoples, at least those that aren't supporting this government. However, if there is one bright light in this fog, it is that in spite of all their concerns, in spite of the lack of consultation, in spite of not being heard, even on the bill that says they must be heard, Indigenous peoples still want this bill passed. Hope springs eternal. In hope against hope, they continue to fight for their rights and incrementally inch forward in that effort. Their patient determination is slowly but surely bearing fruit, with no thanks to this government. However, I urge you, colleagues, not to see this bill as some kind of a panacea, because I can assure you that our Indigenous peoples do not see it that way. The Mohawk Council of Kanawaki has noted that, and I quote, Section 35 of the Constitution Act 1982 applies of its own force and effect. As such, this non-derogation clause is at best a reminder of well-established constitutional limits. It does not provide any substantive legal benefits to Indigenous communities. Chief Jessica Lazar added that, at best, such clauses are like post-it notes pointing to the Constitution. Make no mistake, colleagues, this is what Bill S-13 will do. It will place a post-it note on every piece of legislation, reminding this government what it already knows full well. Aboriginal and treaty rights have not been granted. They are inherent. They are not to be abrogated or derogated from. They are not subject to negotiation or subjugation. Rather, as stated on the website of the Department of Justice, the rights of Indigenous peoples, wherever they live, shall be upheld. Colleagues, I encourage you today to support this bill. I will. I think all my colleagues here in our caucus will. Support this bill, not because it will change the way this government behaves, because it won't, but because it salutes our Indigenous peoples for their perseverance, their undying optimism, and their unflagging efforts to secure what already belongs to them. Thank you, colleagues.